in every decision, it is the parties who know the truth. The judge is in the dark. Secondly, in my court and in my career, I have to do justice between the parties. And how do you arrive at justice is looking at the evidence critically and whether a case has been made in respect of a particular proposition. Here is the case was not about matrimonial dispute. It was under Section 17 of the Married Women Act of 1882. There was no divorce between the couple. So what was before court was a declaration that she's entitled to half or 50% of the property. These couples, from the evidence on record, they got married in 1970. At the time of marriage, the lady was working. She had a business. And then thereafter, she was employed. The man was also working. He was working in a garage, but later he was employed in Kenya Post Office. They went to various places. But as they went to various places, there was one constant thing. The lady had her own separate businesses. And the parties acquired properties separately. For example, in the Nyahururu house, or the Nyahururu property, which was 5 acres, that was their original matrimonial home, where they kept everything, the chickens, grow something. So that was the original matrimonial home. It was registered in the name of the lady. After retirement, the man bought a property in Nakuru, which is the subject property. In the middle, he was unable to pay the loan. And they also had separate businesses. They had 3 hotels in Nakuru, in Eldoret. The lady has her own, he had his own. The lady has her own shop, also in Nyahururu. She was selling other businesses. So it is not like an ordinary, informal women who were engaged who could not account. She had a bank account. For example, when the property in Nyahururu was sold, she banked the 500,000 in her account. And when the man asked for money to offset the loan, the lady did not pay. What happened? What happened is this. This man was sick, from the evidence on record. He was unable to buy medication. His eldest son was also living within the premises. He was threatened by his eldest son, who broke into the main bedroom. There was fracas in the kitchen. This is all evidence. And as a result of his financial position, he decided to sell the property. When he was selling the property, he shared that information with the wife. And this is evidence from when the demand for rent was made. They went to the people, the Resma people, and asked for time. And the question arose whether they should be given 1 month or whether they should pay 13,500 or something like that. So it is not a question whereby the man sold the property behind the lady. So she knew that this man was selling the property. Again, 1 month after the transfer and 1 month after requesting to be given more time, the lady filed an injunction. And she got an injunction 1 month later. The case, the man took the position that the lady knew that he was selling the house, he was selling the house, and that they have agreed to build another property in a place called Mwariki. Kiambogo, and that is in evidence. The man wrote a very comprehensive affidavit when he was sued together with Resma, and said, all along my wife knew, and I sold this property because I was in financial needs. I could not buy even medicine, and I was sick. And I was buying because my son wanted to burn this house. That is the evidential position. And he says this man is innocent, Payaf, and we have the money. 8 years later, after the death of the lady, the man now signed another affidavit and said, I have sold the house, but I want my family and my children to inherit it. But I am willing to pay 15,000 shillings per month to refund the money. The case was handled by many judges, including the Honorable Chief Justice at one time. Maybe she doesn't remember. Way forward, it is not a case of where an ordinary lady who could not provide documentary evidence. These are two parties who had separate life, separate properties. And what is the role of the court? The role of the court is to look and stand between the parties. Here is Resma, who bought this property, but who could not get his money, even when the judge ordered and said, keep the house, but refund the money. No money was refunded. Even when the matter came on before us for appeal, we asked, what is the position? Can you have a settlement? The answer we got is that give us judgment, Resma can sue. And when we ask, they sue who? They sue the person they want. So I fully understand the responsibility of a judge in terms of acquisition and distribution of matrimonial property. And I have dealt with many matters in the Court of Appeal in terms of such kind of dispute. In fact, this matter which we have referred to, which is also a leading decision on matrimonial distribution, was certified by myself and Commissioner to go to the Supreme Court, the JAO matter. The JAO matter, and we raised pertinent issues, whether, for example, Article 45.3 is an automatic 50-50 apportionment. And all these circumstances, and when we have looked at the analysis and the evidence, we have arrived at this man was an innocent purchaser in the circumstances of the case. I am alive to the fact that there are certain documentary evidence in an ordinary rural life which cannot be accounted for, and they may amount to indirect contribution. I have several cases in the Court of Appeal held that this is the way to go. But this is not an ordinary case. This is where parties kept their businesses separate, their property separate, and the lady knew this man sold the property. This is an information correct.